never come across on a specific treaty which is monitoring issues of performances. And still, we are actually relying on national laws of a specific country. That's why I have been several times referring on our laws of Tanzania and the WIPO Treaty. But bad enough, in Tanzania, the WIPO Treaty is only persuasive. You can even refer it just to see how these rights are protected, but it's not binding on our side. And before the end of my presentation, I will show some of the few countries in Africa which has already ratified this treaty, to which also this act as a barrier of some of the rights of performers are not well implemented and enforced in Africa. Okay, for sound recordings, some of the writings are defining a sound recording as the process of making a record of sound. You are making a record of a sound, and this, once you made a record of a sound of a certain kind of, it might be a song or whatever, you are automatically protected, and now you can also own it. And so when the key question can be, when does copyright protection of sound recording start or can it begin? And it begins once a person records that's sound and make some of the fixations. But I know some of the country fixation is not mandatory, but a mere recording of a sound, still you can start having those rights, and you can also even enforce them. And no need of registration. But when it comes to issue of registration, actually it remains also based on national issues. For instance, in Tanzania, it's not mandatory to register a performance or a sound recording. But when you want to also to enforce your rights through maybe suing a third party who has infringed your rights, first things the court will ask itself is whether that performance has been registered. So for ease of proving the infringements, the first issue is for the owner of that right to show the certificate from, in Tanzania we have COSOTA, and which is a specific registry for registration of copyright issues. So you have to bring a certificate as your first exhibit, as to indicate that you have registered your work and that work has passed through various assessments to which it has been proved that that work is yours. So it's not mandatory to register your performance or sound recording or live performance, but when come to infringements and any kind of rights which you want to enforce it through court of law, registration is one of the key issues which the plaintiff has to prove before the court come to a conclusion whether there was infringement or not. And rights which sound recording, or the person who has a copyright of sound recording can enjoy, including the right of making copies. He can even make duplication of copies of his performance or sound recording which he has made through different kind of media. And also another right is a right to sell and distribute. Also, this is one of the rights which the sound recording, live performance, and audiovisual can also enjoy. Another thing is right to prepare a derivative. So you can even change it in a mode. Maybe it was first you make a sound recording in Swahili, especially for Tanzania, and then you can even change it in English. Still also you have those rights, and anyone else is not allowed actually to make a derivatives of that work before seeking approval to the owner of that performance, sound recording, and audiovisual. Also, as I said, the need of registration is not mandatory, but it's an issue when it comes to enforceability, enforceability of your rights on infringement cases. Live broadcasting also enjoy the same rights, and all of these kind of rights are clearly provided from Article 7 to 10 of the WIPO Performance and Phonogram Treaty. And before marking the end of my presentation, I would like also to give some of the issues which have been also reported in Tanzania. as I said, registration is one of the key issues. And it happened some years ago, we had a case of Emmanuel Mgaya and others, alias Masanja Mkandamizaji and IPP Media. Actually, the key issue was the trademark issue, but in mid of that case, it came an issue of copyright issues, performances, to which the IPP Media even tried to convince the judge that these people should abandon the use of the word the comedy, also even the nature of performance of that kind of the copyright issues. But when the court came to a conclusion that the issue of performance of a work is a moral and economic rights of the performer and not to the media. The media can own a trademark of that kind of a performance, but the performance remain with the one who was performing. So performance and other IP issues also can relate, but they are also but you can even distinguish them when come to a nature of your right, which you want also to enforce at the moment.
All right, Mr. Odinga, please can you wrap up for us? Your time is over. All panelists, can you also turn on your videos, please?
Okay.
All right, thank you.
I think, yeah, thank you. Actually, that was one of the part of my presentation, and also I can invite others also to proceed. Thank you.
All right, thank you very much, Mr. Odinga. We would have our second speaker. Victoria, please, is our video ready? If it's not, we'll just go. Sorry, Victoria.
Yes, Winnie, can you hear me?
Yes, can hear you now.
Yes. Please let's proceed with the speakers, and then we'll do that at the end of the presentations.
Okay, all right. Please, to our attendees, if you have any questions, kindly put them in the chat below as the presentations go on, so that at the end we can address all questions. Okay, so we'll have our second speaker, Mr. Toyosi Odumbaku, and he's from Nigeria. Our first speaker was Mr. Jeremiah Odinga from Tanzania, and so he sent us through, or he walked us through how performers' rights, the law on performers' rights in Tanzania is being enforced, and what it means to have performers' rights in Tanzania. So now we'd have a perspective from Nigeria from Mr. Mr. Toyosi Odumbaku. Yes, so sir, you can please take us through now.
Hello.
Hi,
yeah,
yes.
Thank you again for having me at this time. So I was given a topic, exceptions to performance rights. And as Mr. Odinga rightly identified, the origin of performance rights emanated from the Rome Convention. And of course, the current treaty that governs performance rights is the WIPO Treaty. However, of course, this is subject to each jurisdiction and how they want to enforce those rights. But, you know, having a look at the WIPO Treaty, you will discover that there is no clear exception apart from the limitation in terms of the time frame of 50 years. And of course, further, the WIPO Treaty says that exceptions will be determined by each jurisdiction, you know. So you have a situation whereby you have to look at the infringement clause in relation to the performance rights to decipher exceptions to performance rights as it governs each jurisdiction. And so, you know, the first thing you see when you look at performance rights, as Mr. Odinga has rightly identified, is that it's seeking to give